Hello and welcome to Hofstra Law School's faculty interview series. I'm Kristen McMahon. With me today is Ronald Colombo, Associate Professor of Law at Hofstra Law School. He teaches courses in corporate, securities, and contract law. Welcome, Professor.
Thank you.
So recently the Supreme Court heard oral arguments in the case Morrison versus the National Australia Bank. Can you tell us a bit about it and what the core issues are?
Certainly. Morrison versus National Australia Bank is a case concerning securities fraud. What happened was the National Australian Bank committed the securities fraud. And here's how it happened. A subsidiary, a mortgage company owned by the bank that's located in Florida in the United States, cooked its books, overstated its assets by about $2.2 billion. Those numbers were then transferred to the parent company, the National Australia Bank, and those numbers were then included in the final results and the final rollout of National Australia Bank's financial numbers. So that's how the fraud occurred. It occurred at a subsidiary, but it wasn't published by the subsidiary. It was then rolled up to the National Bank, and those numbers were incorporated in the National Bank's overall financial statements. And what happened was some investors, Australian investors, purchased stock in this Australian company on the Australian Stock Exchange. And when the fraud came to light and the stock declined in value, these investors sued. Now you might have assumed they would sue in Australia, but instead they sued in the United States of America. And that's the key issue. You said, what's the important issue here? The key issue is whether or not these investors, foreign investors, suing a foreign company for stock purchased on a foreign exchange, can sue that company in a United States court of law.
So why did they decide to move forward in the U.S. courts as opposed to Australia?
Yeah, that's a great question, and that's precisely why this has made its way to the Supreme Court. It's an important question. This is what's called an F-cubed, or a foreign cubed case, meaning you have a foreign plaintiff, a foreign defendant, and a purchase of stock on a foreign stock exchange. And so why are they suing in the United States of America? Well, there are two reasons. For one, some of the fraudulent activity did occur in Florida. The Florida team of the Florida subsidiary of the bank is the one that cooked the books. So that's the factual connection to the United States. But beyond that, there's what's called forum shopping going on here. American securities laws are, I don't want to say notoriously pro-plaintiff, but they're known worldwide as being friendly toward securities class actions and securities fraud plaintiffs. And as a result of that, it made more sense to sue in the United States and under U.S. law than to sue in Australia under Australian law, which would have been less hospitable to the plaintiffs.
And I understand you co-signed onto an amicus brief in this case. Can you explain your position and how you think the court should find?
Yes. Myself, along with several other securities law professors, signed on to an amicus brief that's advocating what we'd say is a bright line approach to this problem. And let me back up and tell you a bit how this case made its way to the Supreme Court. The Second Circuit Court of Appeals, which is the court immediately below the Supreme Court, ruled in favor of the defendant and ruled that the plaintiffs could not go ahead with this lawsuit in the United States. Why? They said that Rule 10b-5, which is the main anti-fraud securities rule that's in play here, does not reach that conduct. We agree with that result, but we don't agree with its reasoning. The Second Circuit applied a multi-factor approach and came to the conclusion that the amount of fraud committed in the United States was not substantial enough to allow the case to go forward in the U.S. We find that rule problematic for a variety of reasons. And because we find it problematic, we're suggesting that the Supreme Court instead adopt a bright line rule and say, quite frankly and quite bluntly, Rule 10b-5 does not reach securities fraud that occurs on foreign securities markets. In other words, if the stock is purchased on a foreign securities market, it's not a U.S. securities law issue, and Rule 10b-5 does not apply, and you can't sue in federal court over this. And if I may, there are some important reasons for this, and this is why I signed on to the amicus brief. We think that the text of the rule itself and Congress's statute that gave birth to this rule is pretty clear that it only applies domestically. Two, canons of judicial interpretation would suggest that this rule not be applied extraterritorial. In other words, there's a presumption that unless a rule clearly has an extension beyond the United States, clearly has such a scope, we don't assume it does, we presume it does not. And so if you apply that canon of interpretation, that supports our position. Thirdly, you look at congressional intent. You look at the testimony at the time this rule was adopted, or should I say the statute, Section 10B of the 1934 Securities Act. When it was adopted, all the intent suggests it was domestic only in scope and not to be applied outside the United States. And then there are public policy issues too. Our courts are busy enough policing the securities fraud that happens in this country, which keeps them, like I said, quite busy. I don't know if it makes sense to open their doors to securities fraud that occurs in foreign countries.
So it sounds like there are international implications, though, depending on how the court finds.
There are enormous national implications, international implications, which is why the governments of the United Kingdom, France, and Australia have each submitted amicus briefs of their own, asking that the Supreme Court uphold the Second Circuit's decision and conclude that Rule 10b-5 doesn't reach this. These other countries don't want the United States to impose its securities law upon transactions that occur on their securities markets.
And is this the first case of this type to make it to the Supreme Court, or have there been others?
No, this is the first time the Supreme Court has heard a case like this, which is why it's particularly important.
And when the judges were questioning the attorneys during oral arguments, did their questions give any indication as to how they may find in the end?
It's always dangerous to try to read into their questioning, because some of them play devil's advocate. That said, the oral argument did strike me as particularly skeptical of the plaintiffs in this case, meaning it looked as though the Supreme Court is leaning heavily toward upholding the Second Circuit's decision, which threw this case out. The question is, are they going to uphold it based on this multi-factor approach that the Second Circuit applied? Or are they going to take the bait and accept our standard, which would be this bright line approach that we're pushing upon them?
And would that preclude other cases from being brought in the U.S. courts?
Our approach most certainly would, because our approach would make clear that any securities fraud that occurred on a foreign securities market could not proceed in U.S. court. If the Supreme Court instead simply affirms the lower court decision of the Second Circuit and adopts this multi-factor approach, well then another plaintiff could try again, and maybe his or her luck might be different if that plaintiff were able to show a more substantial tie to the overall fraud to the United States.
Interesting. And do you know when we can expect a decision from the court on this?
Last I heard is that the court's expected to decide sometime this summer, probably by end of June.
Well, thank you so much for sharing your thoughts with us. For more information about Hofstra Law School, visit law.hofstra.edu.